You're just security, Elijah. Stick to badges and cameras. This isn't your concern. It became my concern the moment I found it, Mr. Doyle. That's exactly what I'm trained for.
They called me just security and fired me without cause, so I let a judge read the file that said otherwise. My name is Elijah Kane. 5 years as a military police soldier in the Army, most of it spent on chain of custody duty. Ammunition depots, medical supply convoys, the kind of work where a missing case doesn't just cost money, it costs lives. I came home and took a job as director of security at a Corvale Pharmaceuticals distribution center, the exact kind of role my Army training was built for. On paper, the company said they valued that background. In the room, most days, I was just the guy who checked badges. 14 months in, I ran a routine audit of our controlled substances storage and found a discrepancy that didn't add up, a pattern of small withdrawals that matched no prescription order on record. I'd seen exactly this pattern before, on a smaller scale, guarding an ammunition depot overseas. I filed the incident report the way I was trained to, time-stamped, detailed, escalated up the chain the same day. Preston Doyle, the CEO, called me into his office a week later, not to thank me, to tell me to drop it. "You're just security, Elijah," he said. "Stick to badges and cameras. This isn't your concern." "It became my concern the moment I found it, Mr. Doyle," I told him. "That's exactly what I'm trained for." 15 days after that conversation, I was fired. The paperwork said, "Termination without cause. No explanation required," which is exactly why they chose that wording. 2 weeks after 14 months of clean performance reviews and one inconvenient incident report, I hired an attorney named Priya Nair, who'd handled whistleblower retaliation cases before. She didn't need long to build the timeline. Doyle had personally read my incident report the same day I filed it. The email metadata proved it. He'd ordered my termination 12 days later. And under federal law, companies handling controlled substances have a mandatory window to report discrepancies like the one I found to the DEA. That window closed 3 days after I was fired. Nobody at Corvale ever filed the report. The one person positioned to make sure it happened was gone before the deadline even arrived. The trial in Hartwell County turned on one moment. Priya asked the court to enter my full personnel file into evidence, including Corvale's own hiring notes from 14 months earlier, which specifically cited my Army chain of custody certification as a reason they'd hired me for the role. Judge Miriam Castellano read that hiring note aloud, then asked Doyle directly why a company that hired a man specifically for that expertise had dismissed him the moment he used it. Doyle didn't have an answer that held up. The judge found Corvale had retaliated against me for reporting a suspected controlled substance discrepancy in direct violation of whistleblower protections, and that the company's own missed DEA reporting deadline was a direct consequence of that retaliation. She ordered reinstatement, back pay, and damages, and referred Corvale's compliance failure to the DEA for formal review. I didn't go back. I used the settlement to start a small consulting firm that helps companies build the kind of reporting systems that can't quietly disappear a problem, staffed almost entirely by veterans with exactly the background Corvale once called just security. They said I was just security. The file said I was the only one in that building who knew exactly what he was looking at. If you believe in the men and women who wore this country's uniform, drop faith in the comments below.